My lord, I crave your lordship's indulgence mentioning item number 7. Taking the consent of my learned friend, Lord, let it come in the first week of February. my lord. I have to make some correction in the petition.
Heard Mr. S. Datta, learned senior counsel, who prays for an adjournment on the ground that he has to make some corrections in the
Statement in the petition.
Petition filed by the petitioner. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed. Let this matter be listed in the first week of February on a date to be fixed by registry.
I'm appearing for respondent number 1 in this case. May I pray this matter may be fixed on 4th of February, subject to the convenience of my seat.
Show the name of Mr. D. Chakravarti, learned counsel for the respondent number 1 does not raise any objection. Let this matter be listed on 4th of February.
Grateful to you.
May please your lordship, with consent of the other side, your lordship, I beg to mention item number 15 and 16, your lordship. Item 15 and 16, your lordship.
What is your prayer?
My prayer is that this matter will be adjourned today and fixed on the Thursday. My senior's brother is, because of the serious condition, is admitted in hospital, your lordship.
Heard Mr. L. Mohan, learned counsel for the caveator, who prays for an adjournment on the ground of personal difficulty of conducting counsel for the caveator / respondent. Also heard Mr. S. K. Poddar, who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed on Thursdays, 8th of January.
May I please, your lordship? With due consent from the other side, my lord, I beg to mention item number 46, my lord. Let the matter come after vacation, my lord. A date may be fixed, my lord.
46.
Lord.
Heard Mr. T. Uloskar, learned counsel for the applicant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. J. Loskar, learned counsel for respondent number 1A to 1D,
Right.
who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed on 21st of January.
Obliged.
With respect to item number 1, actually I paid for today's accommodation.
Item number 1.
Wow.
What is your prayer?
So we are yet to get instruction from the petitioner's lordship. And here, lordship, we have taken steps upon the sole respondent lordship by way of paper publication lordship. That
No,
was done,
service is complete on sole respondent.
service is completed upon the sole respondent. That was done through paper publication lordship. But my
Heard Mr. Your R. Sharma.
JM Gogoi lordship on behalf of BD Goswami.
Heard Mr. J. M. Gogoi, learned, submitting on behalf of Mr. B.D. Goswami, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed
As per convenience of the court.
after Bihu vacation on a date to be fixed by registry.
Obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 24 to 39, Lordship, with due consent of the other side, Lordship. Lordship, the conducting counsel, learned senior counsel, Mr. A. Thakur, is out of station, Lordship, due to his post-operation checkup, Lordship. Is in Delhi, Lordship. So kindly, Lordship, please stop the due vacation, Lordship.
Okay.
His daughter also with him, Lordship.
What is your name?
T. Thakuria, Lordship.
Heard Mr. T. Thakuria, learned counsel for applicants. Item number 24 to 39. Who prays for an adjournment on the ground that the conducting counsel for the applicants, Mr. A. Thakur, is indisposed. He will.
He is in hospital, Lordship, at
Okay.
Delhi, Lordship.
He submits that you have informed the other side.
Yes, Lordship, already informed.
He
Yes,
submits
Lordship.
that he has informed learned counsel for the respondents regarding his prayer for adjournment, who has no objection to his prayer. Hence, the prayer is allowed. February.
After due vacation, Lordship.
Let this matter be listed again on sixth of February.
Sixth of. in the
Is
month-
it okay?
The month of January is possible, Lordship, after revocation.
Sixth of February.
Wait,
Yes,
Mr.
Your
Lordship, I beg to mention item number 2 from today's statement. In this matter, we were supposed to file an affidavit in reply, my lord. But the thing is that, my lord, our client is unwell, my lord. We are unable to get the sign, my lord. So I am praying for accommodation for today, my lord. We are going to file.
You have
it by
informed
next-
the petitioners.
No, we will inform,
You have not informed.
not inform. my lord.
Wait,
We will-
wait for your turn. Let the matter be called.
Item number 14, Lordship, the bail hearing matter. After a CD not received, Lordship, IO is in leave, Lordship, so he needs some time, Lordship. I will inform Lordship the. Okay, sir.
Okay, otherwise we will take it up as first item. You wait for some time.
3. The order matters may be passed over for the day.
Why?
As Mr. Learned Counsel Gio Ahmed is out of station for illness. So matter. may
You have
take-
informed the other side.
Your Lordship,
What is your name?
Padev Burman.
Heard Miss B. R. Dev Burman, learned counsel for the applicant who prays for an adjournment on the ground that Mr. G.U. Ahmed, learned counsel for the applicant, is out of station. She submits that she has informed learned counsel for the respondents regarding her prayer for adjournment, who has no objection to the said prayer. Hence, the same is allowed. Let this matter be listed on 19th of January.
Lordship, CD not.
None has appeared for the petitioner on call. Miss N. Das, learned additional public prosecutor, submits that she needs some more time for production of the case diary. The prayer is allowed. Let this matter be listed again on when?
20, Lordship.
20, on 20 January.
Okay.
Please, your lordship. I was praying for accommodation in this case, my lord. Because we are supposed to file the affidavit. We have drafted it also, my lord, but the petitioner is unable to sign it, my lord. Let's see
It
it
is not
unwell.
maintainable. On the point of maintainability, we have already. filed.
Your case is not maintainable.
We will
It
be
is-
filing
it
the
is
reply, my
applicable-
lord.
it is
Kindly allow us
applicable.
some time. We will establish that our case is maintainable.
No, apparently it is not
Not
maintainable.
maintainable. It is applicable order. More by
What-
file under section.
Just give us some chance. To
What
file the
chance?
Counter to the affidavit filed by them.
What counter you will be filing? When, how much time will you require?
By this week, we are filing.
Against mandatory provisions.
By this week. my
Oh,
lord.
okay, let him. Heard Miss, what is your name?
Yes, Upadhyay.
Heard Mr. S. Upadhyay, learned counsel for the petitioner. Also heard Mr. K. Sharma, learned counsel for the respondents. Learned counsel for the petitioner submits that he may be granted some time to file an counter affidavit against the written objection filed by the respondent side regarding the maintainability of the instant civil revision petition. The prayer is allowed. Let this matter be listed. 19 January.
After 19. my lord.
After 19.
Make it 27 or 28.
27 January.
I'm deeply obliged.
Let this matter be listed on 27.
On both points, it is filed under section 227 constitution, not maintainable. It is 115 of the CPC.
We will try to
Applicable order.
establish.
Let them file written.
Applicable order.
I'm highly obliged.
Your Lordship. Your Lordship, the case is conducting by Mr. S. Chauhan, Lordship. He is out of station on the way to Guwahati from Kolkata. Kindly accommodate the matter.
What is your name? What is your name?
A.J. Ghosh, Lordship.
Heard Mr. A.J. Ghosh, learned counsel for the petitioner who prays for an adjournment on the ground that Mr. S. Chauhan, learned conducting counsel for the petitioner, is out of station. No one has appeared for the respondents. The prayer is allowed. Let this matter be listed February 21st of January.
Pleasure.
May it please, my lord. My lord, before my respected senior starts, my lord. My lord, I seek adjournment for the day. We are to file our reply, my lord, in the case file. I appear for the respondent number 3, my lord. Some time may kindly be granted. I appear on behalf of Mr. M. Sharma. Respondent 3, my lord.
Yes, Mr. Das, any objection?
Let him file an
Heard Mr. A. Das, learned counsel for the petitioner. Also heard Mr. P. R. Sharma appearing for,
Mr. M. Sharma, respondent number
appearing
3.
on behalf of Mr. M. Sharma, learned counsel for respondent number 3, who submits that the respondent number 3 intends to file a written objection against the prayer of the petitioner and seeks some time for the same. The prayer is allowed. Let this matter be listed on 22nd January.
My lord, some more time may be given.
February,
Go for-
February
go
month.
for vetting.
On 4th of February.
Interim order to continue.
The interim order shall continue till next day.
Deeply offended.
May I please, your lordships? Your lordships, in this case has already been disposed of as a
May-
CRP. I had ordered it, your lordship. 11/3/24. In fact, what happened, your lordships, I have filed CRP against rejection of plant.
Rejection of claim.
Wherein your lordship appeal lies.
Okay.
So this is a mistake, thereafter your lordships, the lordship was pleased to convert it into the appeals, and I have asked to pay your lordship this court fee. Accordingly, I paid. And thereafter it was disposed of on 11/3/24.
Which case was disposed of? This case. This CRP was converted.
Into appeal, but it
Okay.
was, in fact, your lordship, the last order, your order may be perused.
Which order?
Order is 11/3/24, your lordship. And order disposing the.
Okay, this is a disposed of case.
Yes, your lordship.
Why it has been listed?
In fact, what when your lordships, as there was order of converting it into the appeal, so it was listed, your lordship. In fact, on the last, your lordships, the last para 19, your lordships, the registry is, your lordships, para 19.
Yes.
The registry is further directed to renumber the instant case as a regular first appeal and thereupon shall provide the certificate copy. It has not been
Okay,
done.
okay,
That is the mistake.
okay. Heard Mr. N. N. Jha, learned counsel.
And I'm sorry, your lordships, the brief have already returned after disposal, so I have no view.
Okay, no issue. N. N. Jha, learned counsel for the petitioner who submits that this instant civil revision petition was directed to be renumbered as a regular first appeal by order dated 11/3/2024. Stop. However, by the said order, this case was disposed of and only direction was given that before issuing certified copy, the case should be renumbered as a regular first appeal. Hence, nothing is required to be done in this case, as case has already been disposed of. The registry to do the needful in terms of directions given by the order dated 11/3/2024, passed in CRP case number 5356/2023, and treat this regular first appeal as disposed of by the said order, within bracket order dated 11/3/2024.
Much obliged.
Item 6.
May I please?
Disposed.
I pray for accommodation for the day in this matter, Lordship. Today my senior Mr. T.J. Mohan has some difficulty. Any date, Lordship, after Bihu vacation, Lordship.
Yes, Mr.
I'm hearing for a fixed date.
Okay, heard Mr. T. Gogoi,
A Borua.
heard Mr. A. Borua, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting senior counsel for the petitioner, Mr. T. J. Mohanto, has some difficulty on today. Learned Mr. A. Ahmed, learned counsel for respondent number 1 and 2, raises no objection. Mr. T. Gogoi, T.R. Gogoi, appears for learned senior government learned government advocate, appears for respondent number 3, 4, and 5. The prayer for adjournment is allowed. Let this matter be listed again on 4th of February.
Lordship.
Item 8.
Madam,
Yes.
I pray it may be taken up after some time, madam.
Today itself. Today.
Today, madam. Subject to madam.
Well, I have one thing. The petition is incomplete product. The so far page number to Lordship candidate to page number 43. One page is missing. The paragraph number.
Which page is missing?
One page is missing, but serial number is there. So far, I do that. Written statement and counterclaim. This petition for page 43 is the statement and 44 is the schedule. But one page is
In between page 43 and 44, there was
one.
one.
I am.
No, this petition, a written statement otherwise is not an issue. What I will submit is that there was an amendment application and the
No,
amendment was
that is not the matter. There may be amendment application, whatever that may be. But what I submit before your Lordship is this, the petition is incomplete.
This 43 is an extra
Yes,
40
my lord, this is an extra.
written statement.
This is just a part
Okay.
of the pleading. Subsequent to that, an amendment application was
No,
filed.
amendment
against which they filed
application
an
may be
objection.
there. What they have annexed, that is an incomplete document.
Very well, my lord. This was a certified copy otherwise, therefore. it
No,
was
it
an
is.
act.
You make it complete.
Very well, my lord.
Otherwise also, what he has to do? He has to file a
He has to file
additional
petition or
Additional affidavit.
additional affidavit,
whatever that may
bringing on
be,
record.
whatever that may be, but one page is missing.
Yes, rectify that.
Very well.
Heard Mr. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. A. C. Sharma, learned senior counsel, assisted by Mr. P. Devri, learned counsel for respondent number 1, 2, 3, and 4.
No, one to one.
No, learned counsel for respondent number 5,
6,
5, 6, and 7. Also heard Mr. T. R. Gogoi, learned government counsel appearing for respondent number 1, 3, and 4.
Written statement.
Learned senior counsel for respondent number 5 to 7 has pointed out that in the petition filed by the petitioner,
One page. that is-
in the annexure A, annexed along with the petitioner, along with the petition, the page after page number 43 is missing. he submits that there ought to have been one page in between page number 43 and page number 44. Stop. Learned counsel for the petitioner submits that agrees that the said page is missing. However, he submits that same is not in relevant for deciding the issue in this case. However, he prays for some time for filing an additional affidavit to rectify the said defect. The prayer is allowed when
My lord, may I fix it on 28th?
28th. Let this case be listed again on 28th of 28th of January.
My lord, there is an interim order.
The interim order shall continue till next day.
Deeply obliged.
May it please your lordship. Lordship, I am being led by senior counsel Mr. K. N. Chaudhary. Lordship, he is before legs in court number 1. He will be here shortly, your lordship. Pass over for the time.
Okay.
Much over.
Well, this matter be fixed on 9th, my lord. This I am actually might not prepared to the matter 9. Right, my lord.
Heard Mr. S.K. Medhi. You are appearing as Central Government
Yes,
Counsel.
yes.
Learned Central Government Counsel appearing for the petitioner, the appellant, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed again on 9th of January.
My lord.
Item 11.
Kindly fix it on another date, lordship.
Why?
Because the arguing counsel S.D. Borwa is not well today.
Okay. What is your name?
B. Borgo, my lordship.
Heard Mr. B. Borgohai, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Miss S.G., conducting counsel for the petitioner, Miss S.G. Borwa, who is appearing for state. Mr. T.R. Gogoi, learned government advocate, appears for respondent number 1 and 3, who does not have any objection against the said prayer. No one has appeared. For Forest Department? No one has appeared for the Forest Department. Let this matter be listed again on 6th of February.
Much obliged.
Item 12.
I'm sorry, similar prayer lordships after Bihu vacations.
Yes.
Respondent, my lord.
Why?
Difficult on the part of the senior.
What is your name?
A. Dhanuka.
Heard Mr. A. Dhanuka, learned counsel for the petitioner. Also heard Miss, what is your name? D.J. Bora, learned counsel for respondent. Learned counsel for the petitioner prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Learned counsel for the respondent raises no objection to the said prayer, hence same is allowed. Let this matter be listed again, 10th of February.
The interim order may be.
The interim order shall continue till next day.
Item 13. Item number 13.
None has appeared for the petitioner on call. Let this matter be listed on 27 January.
17.
So in this matter, I have filed an IA for withdrawal of Kalatnama. This,
Withdrawal of Wakalatnama.
Yes, but IA may not be on the record because we have filed it just day before yesterday.
Okay, what is your name?
All Oscar.
Heard Mr. O. Laskar, learned counsel for the petitioner who submits that he has filed an interlocutory application wherein a prayer has been made for withdrawal of wakalatnama. However, said interlocutory application is not tagged with the present record. Hence, the registry is directed to list this matter again on 27 January, along with the interlocutory application filed by the learned counsel for the petitioner.
Answer has been received, my lord, but service, I don't know, my lord, nothing is recorded. Sir. Or we may be allowed to
Oh,
take.
You have to take fresh steps.
Yes, my lord, I will take.
How many respondents are there?
One, sole response.
Heard Mr. B. Sinha, learned counsel for the petition, learned counsel for the appellant. Second appeal,
Yes, I can appeal.
a substantial question of law formulated.
Yes, formulated.
The office note dated 2025 shows that the records of the trial court as well as first appellate court have been received. However, it reflects that the appellant has not taken steps for issuance of notice on the sole respondent. You have not taken steps.
I'll take
Yeah, but your appeal will be dismissed if you don't
No,
pay.
no, I'll take it. I'll take it.
Learned counsel for the appellant prays for some more time to the appellant for taking steps for issuance of notice on the sole respondent. The prayer is allowed. The appellant shall take steps for issuance of notice upon the sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after the last part of February. Returnable on 26th of February.
Obliged.
As per office note in 512, notice upon the respondent number 3 has not been served. That has been returned at the seal with remark.
What is to be done?
So we will take 10 steps. If not affected, then we will go for paper publication.
Addressee left.
At the seal.
Who is respondent number 3?
The attorney holder, Jagadish Sharma. He was the attorney holder of the respondent number 1. 1 and 2 has appeared.
Heard Mr. S. Deka, learned counsel for the petitioner. The office note dated 5/12/2025 shows that the notice issued to respondent number 3 has returned with an endorsement within inverted comma, addressee left. So R2S inverted comma close. Learned counsel for the petitioner prays for allowing the petitioner to take fresh steps upon this respondent number 3. The prayer is allowed. The petitioner shall take fresh steps by speed post as well as by usual mode within 7 days of date of this order for issuance of notice upon respondent number 3, returnable on after that last part of February, 27th of February.
Interim.
The interim order shall continue till next day.
Public. Item 20.
Item number 20. None has appeared for the applicant on call. It also appears from office note dated 3/11/2025 that no steps for issuance of notice upon respondent as directed has been taken by the applicant. Stop. Let this matter be listed again on Agudya on 30 January. None has appeared for the appellant on call. On perusal of the office note dated 19/11/2025, it appears that the notice issued to respondent number 1 to 6 has been duly served. Stop. It also appears that the records of the title appeal number 25/2018 has been received. However, the records of the trial court, that is title suit number 60/2001, 2000, records of the trial court has not been received. Hence, issue reminder for the records of the trial court. Let this matter be listed again on 30 January.
My pleasure, Lordship. I'm sorry to say regarding the item number 14, my lord.
14,
Yes, my lord, 1/4.
yes.
The statutory notice award, the petitioner was arrested on 26/9/2025. Today is the 102 days, my lord, behind the bar, my lord. Earlier also, then, my lord, amicus curiae was appointed.
Where were you when the matter was called?
I was in election put number 2, my lord.
You have to inform the,
Item number 2, my lord.
no, you have to inform the public prosecutor, Miss N. Das, because she has already mentioned the matter. We took up this matter as item number 1.
Yes.
So you inform Miss N. Das, we will take it again.
Yes, my lord, I will inform, my
You
lord.
come along with Miss N. Das.
And Das,
Nandita Das.
yes, my lord. And also D. Gogoi also amicus curiae, my lord, appointed earlier also. Yes, my lord.
Yes, you inform both of them. We'll take it up
Yes, sir.
after some time.
Yeah, please, your lordship. Lordship, as per last order, 3/11/25, lordship directed the registry to verify whether the records has been received or not.
It has been received. Service?
Service complete, lordship. Last order itself, it is reflected. 3/11/20.
It will go for hearing.
After 4 weeks, lordship.
Okay. Heard Mr. G. Bhardwaj, learned counsel for the appellant. None has appeared for the respondent. How many respondents are there?
There are many respondents. Five. Eleven respondents.
Where is this? No. Regarding service, there is no order.
Last order, it is reflected, 3/11/25.
This is item number
22.
22. Oh, yes. কি লিখিলে last line? Respondents, though, comma, though, name of Mr. S. Uddin, comma, Mr. S. S. Ahmed and Miss S. Sultana, Learned Council, have been shown as engaged counsel for all the respondents in the cause list. It also appears from office note dated 3/12/2025 that the records of trial court as well as first appellate court have been received. Hence, this case is ready for hearing. Let this matter be listed for hearing after 4 weeks.
Hello.
Lordship, item number 13, I missed that.
Item number,
13 Lordship.
some date has been given. 27. Show the name of Mr. A.R. Agarwal. Item number 13 or
It is in admission, Lordship.
13 record আছে নাকি?
CRP IO, so change of order. Here, Lordship, I filed a case in MSCT. Here, Guwahati, Lordship, my case has been transferred to MSCT Dhubri, Lordship. So that should not be transferred. Like, I am the main claimant, the wife of the deceased, Lordship.
No, for why this IA is there? IA is for delay condonation.
So I for this non-transfer of MSCT case to Dhubri, Lordship.
No, this IA is for what purpose? What prayer you are seeking in this interlocutory appeal?
Oh,
IA. Oh, IA has been disposed of.
yes, Lordship. Court order dated on 19.
When it is fixed. We'll see whether on 27 January the respondent appears or not. Have you taken steps?
Yes, Lordship. Simply stay is there, Lordship. So that-
No, after registration of this, after delay condonation, have you taken fresh steps?
Yes, Lordship, I taken. I've taken the steps, Lordship. On 28/11/25, Lordship. 16/12, Lordship, what I passed that to confirm that whether service is complete or not. By the registry.
You know, you take fresh steps. Likho. Item number 13. Only in CRP, IA is disposed of. Heard Mr. A.R. Agarwal, Learned Counsel for the applicant. This
Lordship, last date, Lordship, orders for confirmed from the registry, Lordship. whether service is complete or not.
No. No, you have not taken steps. You have taken steps only in interlocutory application. You have to take fresh steps. This CRP, this civil revision petition has been registered after condonation of the delay of 47 days in filing the same was done by order dated 28/5/2025, passed in IA Civil number 3150/2024.
In the main case, I have taken steps, Lordship. The delay was condoned immediately on the first day, Lordship, without notice, Lordship.
And this CRP is for,
For my case has been transferred to MCT Dhubri, Lordship. That should not be transferred.
no, which order you are impugning,
Order dated 9/10/2025, Lordship.
by which
My
the
case has been
pre-
transferred to MCT Dhubri.
no, but you are submitting what is not there in record. It appears that prayer for
Order dated 9/10/2025, that I've challenged, Lordship.
order dated,
9/10/2025.
but in your cause title, you have mentioned order dated 9/4/2024.
9/10/2025. 9/10, Lordship.
Where is the impugned order? Annexure 3,
Annexure 3, Lordship.
that is 9/4/2024.
9/4.
You are not briefed properly.
Sorry, Lordship.
You come prepared.
9/4, Lordship.
क्या लिखा?
Lordship, 9/10, Lordship, page number 17, Lordship. Annexure 1. By virtue of this order, my case has been transferred to MCT Dhubri.
In page number 17, there is no order.
Annexure 1, Lordship.
Annexure 1 is the application under 166. You are not briefed properly. You are not prepared properly. Prepare yourself.
Lordship, order dated 9/10, Lordship.
Should I dismiss it?
No, Lordship.
Then you come prepared. क्या लिखा? This civil revision petition under Article 227 has been filed by the petitioner impugning the order dated 9/4/2024, passed by the Motor Accident Claims Tribunal, Borpeta, in MAC case number 37/2024,
No, Lordship.
where
Kamrup, Lordship.
you are submitting something from a different brief. Stop. Let this matter be listed on 27th January. Come prepared.
Yeah, please, Lordship. The victim mentioned to pass over for the matter for the day, my lord. Now, senior is not well, my lord.
I am appearing for the respondent number 1.
You are Mr. BJ. Heard Mr. T. Sheikh, learned counsel for the applicant, who seeks an adjournment on the ground that conducting senior counsel for the petitioner is not well. Also heard Mr. N. Upadhyay.
I am Espada. I am
Eh,
appearing on behalf of.
Mr. S. Upadhyay, learned counsel appearing on behalf of Mr. N. Upadhyay, learned counsel for the respondent, who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed on 30 January.
Deeply available.
Respondent है?
Who is for the petitioner?
Against an order under order 39 rule 1 and 2, a revision has been filed, my lord.
Against order 39,
Rule 1 and
no
Okay.
appeal has been filed.
no appeal, no appeal. Order 43 rule 1 are
1
appealed. As a, in fact, there is a full bench judgment of our High Court also, my
So
lord.
this is not maintainable.
This is not- That is the point.
But where is the petitioner?
That is the point.
What should we do?
The Atipo message. Atipo-
Who is the counsel, Mr. Chauhan?
So, huh.
Let us fix it tomorrow
Will
or day after tomorrow.
Let it tomorrow.
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 Heard. None has appeared for the petitioner on call. Heard. Mr. K. N. Chaudhary, learned senior counsel, assisted by, who is assisting you? Miss M. Sharma, learned counsel for all the respondents,
Yes.
all the respondents. Let this matter be listed again
My lord, instead of tomorrow, let it be on Thursday.
Thursday, 8th of January.
Deep-
None has appeared for the appellant on call. 11. It appears from office note dated 27/10/2025 that the original case record of OA original application has been received from the Railway Claims Tribunal. Case record IC. Stop. Let this matter be listed again on 30 January.
Beg your lordship, my lord. My lord, originally, I just want to draw your lordship's kind attention to page 5, para 3. Page 5, para 3. I'm just reading out the relevant portion for your lordship's kind convenience. The appellant begs to submit the duration of non-appearance on the part of the land counsel for the appeal and applicant is because of sudden admission to hospital.
No,
confounding-
whether notice upon respondent is
Yes, my
complete.
lord, is completed. my- There was only, my lord, dismissed for non-prosecution.
No, against respondent number 5 and 6, it is not complete. Only respondent number 1 has appeared.
We have already taken a stays, my lord.
Respondent number 6, notice has returned without service. Who is respondent number 6? And respondent number 5, no notice.
Respondent number 6 is, my lord, Amildo Deca from Nolbari, my lord.
Insufficient address.
On the very past day, we have taken stays, my lord, I don't know.
You have to take fresh steps.
My lord, as well as the justice service, my lord, we will-
If it can be done by justice service, well and good.
my-
Heard Mr. S.S.A. Rahman, learned counsel for the petitioner. On perusal of the office note dated 8/12/2025, it appears that the respondent number 1 has filed wakalatnama of his engaged counsel, whereas the notices issued to respondent number 2, 3, and 4. No, whereas the AD cards of the notices issued to respondent number 2, 3, and 4 have returned with signatures of the addressees. Hence, the notices on respondent number 2, 3, and 4 is held to be, are held to be duly served. It also appears that notice issued to respondent number 5 has not returned, whereas notice issued to respondent number 6 has returned with an endorsement within inverted comma insufficient address comma RTS inverted comma close. In view of above, the petitioner is directed to take fresh steps for issuance of notice by speed post as well as by usual mode upon respondent number 5 and 6 within 7 days from the date of this order, returnable on 25th February,
My lord,
list accordingly.
my lord, highly obliged, my lord.
Item 42.
Please, Lordship. My lord, the learned trial court record has been received, my lord, as per the office note dated 3/11/2025, my lord. So, my lord, I'm praying this matter will fix for hearing, my lord.
Service is complete
My lord, I am representing only respondent number 1.
and others, how many respondents are there?
There are
Okay,
total 8 numbers.
service is complete. Who is respondent number 1
He is the main respondent, my lord.
and who are the other respondents? They are
They are really,
not related.
not actually directly.
Okay. Heard Mr. N. Deka.
V. Bhaskar on behalf of Endeka.
What is your name?
V. Bhaskar, Vinod Bhaskar.
V. Basford,
On behalf of
appearing on behalf of Mr. N. Deka, learned counsel for the respondent. Also heard Mr. A.K.
UK does.
U.K. Das, learned counsel for respondent number 1. On perusal of the office note dated 3/11/2025, it appears that notices issued to respondent number 2, 3, 4, 5, 6, 7, and 8 through usual mode are served personally are served on them. Hence, the same is held, hence the said notices are held to be duly served on the said respondents. It also appears that the records of the trial court as well as the first appellate court have also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Your order, the leading advocate is busy in another court. So my prayer is to pass over for time being.
Yes, Ms. Chaudhary. Pass over for time being. Okay. Okay, we'll wait for some time. At 2.
Pray for pass over time being, my lord. Mr. Vijay Ghosh is court number 14. Informing myself, my lord.
Time being.
Item 47.
Forty-seven. Mention করেছিলে নাকি? Like. Yes, doctor. Yes. None has appeared for the applicant on call. Let this matter be listed. 27 January.
Meet please, my lord. My lord, substitution applications have been filed for the applicant and respondent number 5. However, I sincerely apologize, my lord. Direction was there to take drastic steps upon respondent number 4, which was inadvertently not taken. If permitted, my lord, we can take that step.
There is delay is there.
Delay is there.
In which case Dasti was directed?
Respondent number 4, my lord.
In which
the
case-
main
which-
RSA, the order is there. Order dated 27/8/25.
RSA. RSA.
Follow
No, who expired?
My lord, 5.
Somebody expired.
5.
5. So you file is
There, my lord.
substitution.
Substitution along with setting aside abatement and condonation of delays.
Which one is delay condemnation application?
There is delay in both, my lord,
Both, your
for the
lordship.
appellant as well as the respondent number 5.
Appellant also expired.
Yes, sole appellant. 6 applications are there in total.
So one delay condemnation is 2893.
That is perhaps for the appellant.
Appellant. And one delay condemnation is no order has been passed in these
Ballot
applications.
was filed on that very day. I think. It was not recorded in the last order. Steps were taken on that
So-
day.
But in these 2 delay condemnation applications, notices are to be issued.
Well, for the legal heirs of the appellant, I am representing, therefore they may file their objections in that, in case of the appellant. For the respondent number 5, notices may very well be issued.
No, let us take one by one. In 2893,
The appellant,
sole appellant,
my lord.
sole appellant expired.
Yes.
The notice will go to the respondents in this case,
My lord, he
On the
is representing a few.
all the respondents.
So I'm representing for 1, 2 and 3 lords.
4,
4, Dusty was directed on the last date inadvertently. that
no,
was-
but there is no order where the,
In the RSA, my lord, the order is there. In these applications, no order has been passed, my lord.
uh, how there can be. Orders have to be passed in these applications only.
These applications were not tagged on the last date, my lord. They were filed on the last date.
So therefore, notice has to go in these applications
Very
actually.
well, my lord. For the respondents which my learned friend is representing.
He will
one-
appear. Okay. Heard Mr. N. Chaudhary. To লিখিব 2893. IA number 2893. Heard Mr. N. Chaudhary, learned counsel for the applicant. Also heard Mr. S. Diffusa, appearing for
1, 2 and 3.
respondent number 1, 2, and 3. This application under section 5 of the Limitation Act 1963 has been filed by the legal heirs of the deceased appellant for condoning the delay of 363 days in filing the application for setting aside abatement as well as substitution of the legal heirs of the deceased respondent. Issue notice to the respondents. Since Mr. Diffusa has appeared for respondent number 1, 2, and 3, no formal notice need to be issued to the said respondents. However, as regards respondent number 4, 5, 6, and 7, the applicant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th February. And in IA number 2896, same. Petitioner or counsel eke thakibo. Heard Mr. N. Chaudhary, learned counsel for the applicant. Also heard Mr. S. Diffusa, learned counsel for respondent number 1, 2, and 3. This application under section 5 of the Limitation Act has been filed by the applicants for condoning the delay of 144 days in filing application for setting aside abatement as well as substituting the names of legal heirs of respondent number 5 on his death. Stop. Issue notice to the respondent. Since Mr. S. Diffusa has appeared for respondent number 1, 2, and 3, no formal notice need to be issued to the said respondents. However, as regards respondent number 4, 5, 6, and 7, the petitioner shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of February. List accordingly. Item number? What happened?
Your lordship order, what High Court order, order dated 3/11/2025.
Item number 40 কি order হয়েছে?
Service has been completed.
No one has appeared. Item number 40 কি order হয়েছে? পড়ি দিও। আপনি লওয়া নাই। We'll reflect, what is your prayer?
As per order dated 3/11/2025, by your lordship, service has been completed. As per order by your lordship. So it may be listed in admission here. It's my prayer.
We have already passed order and I do not remember what order has been passed. So we'll record to Anibo. We'll take it up at 2
My
again.
May please, your lord. I was filed for under section 5 of the Limitation Act for condoning the delay of 456.
For
Condonation delay for substituting the respondent number 4. If your lordship take the knowledge that is 9/11 of 25, then there's a no delay. The advocate of the respondent number 4 has informed us on 9/11. But however, in the abundant caution, we have filed this petition, my lord.
notice will go.
My-
Heard Mr. K. Bhattacharjee,
Ye bacha.
sorry. Heard Mr. K. Bhattacharjee, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed for condoning the delay of 456 days in filing application for abatement also,
But also,
filing application for setting aside abatement and for substitution of the legal heirs of deceased respondent number 4, late Arun Bora. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this
the
order.
respondents are all already appeared except 4. The 4 has died, my lord. He is a different person. That is Arun Bora.
But who is representing?
The Arun Bora was represented by an advocate P. Kalita, my lord. And after his information, then we have to substitute him. Because other respondents are appearing by the another advocates, my lord. Ubhusana building with some other person advocate are there.
But today no one has
Appear, so I'll take the step on respondent number 4, my lord, for substituting.
learned counsel for the petitioner submits that the respondent number 4 has expired.
Yes.
You have to issue notice to the legal heirs of respondent. Now, who are the legal heirs?
Given their brand.
Okay. Learned counsel, kill last name. Counsel for the petitioner has submitted that
Commit Bora.
since the other respondents are duly represented by their engaged counsels in the connected CRP IO number 322/2017, the petitioner may not be required to take fresh steps for issuance of notice on the said respondents. Prayer is allowed. However, as regards the legal heirs of respondent number 4, the petitioner is directed to take fresh steps for issuance of notice upon them by speed post as well as by usual route within 7 days, returnable on 25th February, list accordingly.
Oblige, your lord.
14 officer. The statutory period has been
Not
over.
submitted. I have taken his.
Yes. What is your name?
F.A. Hassan.
Heard Mr. F.A. Hassan. এইটো আগতে কাক ডিক্টেশন দিছিল? অমিতা। অমিতাক কব এই অৰ্ডাৰটো কেনচেল কৰিব, আপুনি লৈ লওক। Heard Mr. F.A. Hassan, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Learned additional public prosecutor submits that the case diary has not been received and prays for some more time for production of the case diary. However, learned counsel for the petitioner has submitted that the petitioner in this case was arrested on
26/9/2025.
26/9/2025, and he has already completed the statutory period of detention and has been detained behind the bars for last how many days?
102 days.
102 days. And therefore, he submits that the petitioner is entitled to get default bail. Stop. Learned additional public prosecutor has submitted that she has been informed by the investigating officer that charge sheet has not yet been filed and the case is still pending investigation. Stop. Considering the submission made by learned counsel for the petitioner as well as learned additional public prosecutor, since the charge sheet has not yet been filed, and since the petitioner has completed the maximum statutory period of detention of 90 days in this case, he is entitled to get default bail. Accordingly, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge
Shri Bhumi.
Special Judge Sri Bhumi.
Special Judge Pokso.
Special Judge Pokso Sri Bhumi. With following conditions, condition number 1 and 2. This bail application is accordingly disposed of.
Obliged, Guru.
Condition Abhishek or Paralwelu.
Obliged.
May I please give your lordship? In this case, as per order dated 3/11/2025, under para 3 and 4, service has been completed, my lord. As per High Court's order. Actually, in this case, my lord, only we claim 5 lakhs of awarded money.
No, where the service is complete.
My lord, as per order, High Court's order by your lordship, 3/11/2025.
Yes.
Para 3 and 4.
3 is not relevant. 3 is, para 4 says that the registry is directed to
Yes,
place track consignment
my
report.
lord. I also submit the additional affidavit on statement consent and also submit by registry of High Court, my lord, in this case. Therefore, this case may be placed in admission hearing, otherwise.
Okay. Heard Mr. What is your name?
HZB Aklas.
Heard Mr. SZB Aklas, learned counsel for the appellants. On perusal of the postal track consignment report of the notice issued to respondent number
1 and 2.
1. And where is 2? 1 and 2 submitted by the respondent by way of an additional affidavit, it appears that the notice issued to the said respondents have been duly delivered to the addresses. Hence, who is one?
My lord, one is
But in Union of India, you have to serve notice on the standing council. There was a direction also on last date.
yes,
You have to serve notice on,
sub. Side to the concerned
you have to be louder.
First time, my lord, we have taken a step on the respondent one directly, but it's for last order to standing council.
So you have to take steps.
Correct.
क्या लिख ले last line? Notice issued to the said respondent. Duly served. Addresses, stop. No, hence noise, stop. Stop. In view of above, the notice issued to respondent number 2 is held to be duly served. However, it appears that by order dated 1/12/2025, the appellants were directed, the appellant was directed to take steps for service of notice on respondent number 1 by delivering the said notice on to the standing council of respondent number 1. However, same has not yet been done. The learned counsel for the petitioners seeks some time to serve the notice on the standing council of respondent number 1. Prayer is allowed. The appellant shall do so within a week from the date of this order. List this matter again on 27 February. First week of February.
Order may be given by
6th of February.
March deceased of deceased. The order money 5 lakhs only we want. My lord, seriously medical ground. My lord.
No, you take steps.
For
30 January. 30 January.
additional affidavit may be given, my lord, on the medical ground.
Yes, you ensure that notice is duly served. And if you want to file any additional affidavit, you may file. Learned counsel for the appellant also sought leave of this court for filing an additional affidavit. The prayer is allowed. List accordingly. ওইটা নাই
May I please the lordship?
Yes.
So we have filed our Wakalatnama. Today is the first case, so maybe same for hearing a lordship.
And for
Hearing a lordship, maybe please for hearing. May I submit lordship?
item number 44. Yes.
Lordship, this is a case filed against an order passed by family court regarding maintenance to the minor child under Y. And it is since 2/4/2024. The last order was, case was filed in 2/4/2024, and on the last evening, Lordship, only 30,000 amount has been paid as this case has been listed before this court
Yesterday,
yesterday evening. And Lordship, my prayer is, I am submitting on the law point, kindly peruse the impugned order, Lordship.
no. First, we have to decide whether we will hear this matter or we will grant her prayer for adjournment. She is praying for an adjournment. You are, today it has come up in orders.
May I bring your estimate?
We will fix it. We'll give a short date for hearing.
I want 5-10 minutes time to submit before this court.
Yes,
Lordship, this order has been passed against the law of the land. That is the Rajneesh versus Nehas case.
which order?
This impugned order which we have silenced, 27/5/2025, page number 477, last part. 477. And Lordship, when this order was passed, no counsel was allowed to enter into the courtroom. And this order has been passed. May I read, Lordship?
Councils are otherwise not allowed in family court.
The client want some permission, court permit the amicus curiae, then it is.
You are aggrieved with the quantum of the maintenance.
And the order was passed directing the respondent to pay the maintenance amount from the date of order, which is against the Rajneesh versus Neha. Against that, we have silenced. And
Now,
on the-
whether the respondent is paying
only on
yesterday.
30,000, and the pending amount is more than 2 lakhs.
No, sir. No, sir. This is completely misleading to the court. Pending amount is 70,000. And it was not in my knowledge that he has not paid. And yesterday when I asked him, he asked for the details and I gave him, and readily he has paid 30,000. And the pending amount is 70,000 as per the order, your lordship. The order dated, kindly come to the annexure
Right.
number 4, last
Right.
page, your lordship. Order dated 27/5/2025, your lordship. And it states that 10,000 rupees, 7,000 to the wife, your lordship, who is a government servant. I want to emphasize on 30, she is earning 37,420. And then 3,000, only 3,000 to the child, your lordship. And then that is given from the date of order. So if we consider that the date of order is on 27th May 2025, considering that date, I am only left with 70,000, and which I have paid
27 May.
30,000, 70,000, your lordship.
Lordship, kindly peruse the last.
Okay,
It is max. It is
wait,
max.
wait.
Lordship,
When
Max,
you
your
will be ready for hearing?
Wait a minute. I have a medical emergency, that's why I'm taking some time. I'm going out, so maybe in February. Yes, sir.
Then you pay all the outstanding amount.
Yes. Sure. Yesterday when I got instruction, I asked my client, he was confused how to pay, so that's why he readily has paid 30.
How he has paid? Yes, you pay remaining amount.
Used to give consent regarding adjournment. Then only the learned counsel
No, sir,
communicated
this
to
is-
the,
So
this,
abs-
immediately
is not
he
even
transferred 30,000.
submitting correctly in the
Okay,
court.
no, let him pay the remaining amount. We'll fix that. Sure.
Then I have no problem if adjournment is taken by this, but he has to clear.
How much is outstanding?
Sir,
If we take it as 10,000 from the date of order.
no.
No, that is disputed. That we will decide.
Order of this honorable courts, last order. This honorable high court's order, last.
Yes.
Three point one. And point number 6. Order it is
Read point number 6.
Further, it is provided that the petitioner shall file an application before the learned trial court for giving effect of the impugned order dated 27/5/2025 from the date of filing of the petition, that is 2/4/2024. And on such petition being filed, the learned trial court shall consider the same in the light of the decision of Honorable Supreme Court.
Whether any decision has been made.
No order has been passed. We have immediately filed petition as per direction of this
No,
court.
this direction can be passed by this court also, instead of there. But for that, we have to hear the matter. As of today, let us take it 10,000 from the date of order. Then how much will come?
70,000 rupees, sir. I have paid 30,000, so labs is the 40,000.
You pay 40,000 tomorrow.
Tomorrow, yesterday has paid 30,000, your lordship.
Ah.
And she is not in trouble because she's a government
That is
job
not
holder.
that
She
is not
is,
the
she
argument
is
you have.
earning 37,000. She's not.
When
an
will you
entitled
pay? When will you pay? No, that is outstanding. That you have otherwise also to pay.
Lordship, yesterday I have paid 30,000. I also have all parents to see. And she has a government job. She is not in the dire necessity, your lordship. I'm not denying
no,
to pay.
that-
I just need some time.
You have not challenged that order.
Lordship,
You have
it
not
is a
challenged.
State and that if they have filed a petition in the trial court, that petition has not been served upon me.
Which petition?
They have stated just now before the honorable
No,
court.
that
Yes.
amount you need not to pay now. But the amount which has been ordered by the court,
Yes.
which you are not disputing, that you have to pay immediately.
Paid your lordship 30,000.
No, you cannot pay as per your own choice of dates.
See,
Yes. The time is not allowed.
time. Yesterday,
When you will be fine.
last week of January or the first week of February, he will pay the remaining amount. Because your lordship, it is to be considered that she is a government job holder. They have accepted it.
No.
She is getting
The
37,000.
question is, you have not challenged that amount. They have come on challenge. So you have accepted
Not
the,
accepted. We will also challenge that amount.
then
But till then, we are readily paying. I'm not in against of paying, your lordship. And furthermore, I want to bring esteem attention towards the fact, your lordship.
heard Miss N. Chaudhary. Learned- Oh,
Once, your lordship.
yes.
She said that without the councils were not allowed.
No, we are not entering into these questions. Either we will hear or dispose of it today. No, listen to me. Either we will hear and dispose it of today, or we will allow your adjournment petition subject to your payment of the outstanding amount.
Yes, sir.
You choose a date when you will pay the outstanding amount.
It
You
is
choose
something
yourself.
it's fine.
And that is,
30,000. It is being fought very harshly upon him, your lordship. She is not in a dire necessity, your lordship. She is a working lady. Both we
those
have to
questions we
consider
are
this,
not,
your lordship.
the order was passed in the month of May.
Me, yes, your
Why
lordship.
you waited till yesterday?
She
When you have
placed
not,
this later on.
no, it is not question of case coming to you or not.
Do not
The
have to
respondent,
This was communicated between him and his previous set of lawyers, your lordship. I'm not in a position to answer that, your lordship, but as of today, your lordship, 30,000 he has paid yesterday. May the honorable court be merciful enough to give me some time. We are not denying the payment, your
how
lordship.
much time you?
Before this next day, your lordship, I'll make him pay the standing amount, your lordship. It was not in my knowledge. Yesterday, I asked him, he readily paid 30,000.
Exactly.
Kindly give it in the February, lordship. I have some medical emergency. Oh, please.
I want short date if adjournment is given, or otherwise she has to pay the outstanding amount, lordship.
February 1st of 10th February,
Then that's
10th
Yes, sir.
February. Heard Mr. N.
Within that,
Chaudhary.
pay the remaining amount.
I'll mention it when to pay. Also heard Ms. P. Das, learned counsel for the respondent. Learned counsel for the respondent has prayed for adjournment as she has been recently engaged in this case and has filed the wakalatnama in this case. When? Today. When have you filed wakalat?
11/8, on 11/8, lordship, she appeared before the trial court. It is on record.
This is a different case, your lordship.
On the other hand, learned counsel for the petitioner has submitted that the impugn order dated 27/5/2025 on the face of it is contrary to the law laid down by the apex court. In the case of Rajneesh versus Neha, reported in 2021 2 SCC 324. She also submits that in pursuant to the directions of this court by order dated 14/7/2025, the petitioner has filed an application before the trial court for giving effect to the order dated 27/5/2025 from the date of the filing of the petition, maintenance petition by the present petitioner, that is 2/4/2024. However, she submits that the trial court has not yet passed any orders on her petition. Stop. She further submits that even the petitioner has, no, the respondent has even not honored the direction of the trial court to pay the maintenance allowance, pay the interim maintenance allowance, interim maintenance amount from the date of the order, that is 27/5/2025. And it is only yesterday that the petitioner, that the respondent has deposited 30,000 against the interim maintenance allowance. She further submits that an amount of ₹70,000, even going by the impugn order, is still outstanding. Learned counsel for the petitioner, learned counsel for the respondent submits that the respondent is ready to pay the outstanding amount of 70,000 before next date.
Not 70,000, 40,000, lordship, 30,000.
Sorry, 40,000 before next date. Considering the submissions made by learned counsel for both sides, the prayer is allowed. Let this matter be listed on 10th of February. Before the said date, the respondent shall deposit the remaining outstanding amount to the petitioner without fail, list accordingly. You are review petitioner.
Yes.
Yes, what happened?
This review petition against the order, my lord, my lord.
Where is the order?
The order is page 143.
Yes, what is your submission?
My lord, in this case, my lord, this revision petition, my lord, because this was by your lordship, in 311, my lord. IO 375 of 2025, my lord. This revision petition was directed against two orders. passed in the two missed case, my lord. One is 269 of my lord, 2025. Another is my lord, 270 of 2025, my lord. Now lordship will kindly see 269 of 25, that is a page, my lord. Uh, 122 million. 269. So this petition was filed under, that petition was filed under order 30 rule 10(2), my lord. And if your lordship look into page 124. So calling for the record of title suit number so and so and so and so.
Yes.
And my lord, 270, that my lord will find it, page 126, my lord. Now, 270 was filed, my lord, calling for the, my lord, PP case record of 30 of 1973-74, my lord. And the ground assigned, my lord, if your lordship look into page 126, why it was necessary? We have stated in, my lord, there in clause 1 and para 1, 2, and 3, my lord. 3, 4, my lord.
What is PP case?
Partition case, my lord, because the title suit was filed. In that title suit, my lord, and decree was part for partition of the suit land, my lord. And then a PP got registered by the revenue authority, my lord. And in pursuance of PP case, my lord, the original patta was divided, my lord. So therefore, my lord, for determination of the, my lord, they identify the loan. So we call the record of the PP case, my lord. Paid for the calling of the record of PP case. Now lordship will find page 1. Para 1 of that petition, my lord, annexure 6, page 126.
Yes.
My lord will, may I read lordship?
Yes.
That as per execution petition filed by the DH so and so, it revealed that before filing the title.
No. Before you read, what is your ground for this review?
My lord, ground for review, the lordship is, in my humble subject to lordship's correction, my lord in this judgment are dealt with only 269 of 225, my lord. But though 271 also there is no, in my humble subject, there is no decision on 270 of the 25, my lord.
In 270, you prayed for calling
yes,
of
my
the
lord.
partition case record.
Yes, my lord.
Okay.
Now, my lord, the execution then, right, in the execution, my lord, what the order by this honorable court regarded on 26/11/2025, if your lordship kindly see, this PP Patta case number mentioned there for execution of the decree, my lord. So therefore it is necessary because Patta has been divided in pursuance of that decree of the court, PP case, my lord. So therefore we prayed for calling of the record, my lord. So I may submit that, my lord, I had another point at any point of time, this petition, my lord, required to be, in my humble submission, this required also to be dealt with, my lord, by my lord. Automatic.
Can we have?
Yes.
Top matter, because that has only been considered by the appellate court as well as second appellate court by the court.
Fix, my lord, next week, my lord.
No, we will hear it today
Yes,
if you are ready.
Yes.
let me, on the next, my lord, date, my lord, today, on the order.
Do you agree to that this order regarding 270
Yes,
has not been dealt with?
Well, that is not dealt with.
That is a fact.
That's-
So, okay,
That's a
so
But,
recall, my lord, that order has to be recalled first.
but,
Yes, and
then,
then, my lord.
not necessary, because
Yes, why?
review that can be done.
Otherwise, that will remain
Because
in the book.
Otherwise also two orders cannot be challenged a single review.
No, that,
Two orders, separate orders, but I am not opposing to that, my lord. Your lordship
this
can.
order may be recalled
your-
first, my lord. Then only, my lord, hearing can. There is a procedure.
okay, then we'll hear it today. You are ready or not?
I don't fix over 5 day also. Today, my lord, I fall because I understand the record should be, if your lordship allow this review, then first order should be recalled, my lord, and then a date should be fixed for hearing of this petition along with. all this. Lordship has only dealt with 269 of 25, only lordship and I have to take into consideration 270 of 25, and the order may be passed.
No, for allowing or disallowing that review, I have to hear both of you.
Because
The,
since it is admitted-
your grievance is that one order was not dealt with by
It
the
is a
MP.
senior friend also, my lord. That it will not be dealt with in the order. It's not that, if there is no dispute on that, quarrel on that.
So after hearing you,
It's
both of you will. That means review is necessary.
This is-
Review is necessary.
Yeah.
Well, review, my lord, the question is this, my lord, your lordships can pass a order, my lord, on the both, my lord. Because this is an application filed for a, not for a court. Whether order 13 rule 10 is applicable or not, that is also a question, my lord.
That will be a merit, my
That
lord,
that
not
is
on-
also a question. Because it
Yeah,
PP case,
simple
more
question
for
is
PP
not
case,
whether this petition dealt
they are,
with
they are
it.
only doing the execution of the matter, my lord.
Yes.
This has been dealt with.
No.
Already symbolic position has been given by the PP case, then why they are necessary, my lord? This is admitted fact.
Well, that is a merit, now the order has to be recalled, my lord, in
Admitted
my
fact.
humble submission. Review is necessary, my lord. My lord, has not admitted, that's not been dealt with, my lord.
No, that or whether order is to be recalled or not,
Not,
that
My
will,
lord, does not reflect my lord 270 of 20. My learned friend is admitted senior friend. That my lord, his order does not deal with my lord, the miss case 270 of 25.
no, if there is an apparent error, I will
Yes, yes.
rectify that error. But that has to be done finally, not in interim manner.
It may be fixed, my lord.
He is not ready today.
My lord, impression that my lord, yes, first this order will be recalled. What we
not
understand in the
not
review
necessarily,
petition, my
not
lord, subject to
necessarily.
lordship.
Not necessary. to
That
done.
if a review, my
Because,
friend has admitted that yes, my lord, there is a mistake, I will not be dealt with, first this order.
No,
will
it
be-
cannot be recalled now. It has to be, if it has to be modified,
Yes.
then it has to be done by final order in the review application. When will be
Friday will be difficult, my lord, Thursday, it may be Thursday.
Thursday? Okay. Heard Mr. B.J. Ghosh, learned counsel for the review petitioner. Also heard Mr. G.N. Sahewala, learned senior counsel, assisted by Ms. S. Todi, learned counsel for the respondent. The main grievance of the petitioner in this review application is that while passing the order dated 10/11/2025 in CRPIO number 375/2025, this court did not deal with order dated, which is the second order.
29/8/2025, my lord. It start from page 136, then extra 7.
Order dated 29/8/2025 passed in Ms. J case number 270
Yes,
slash 2025 in title execution number 5/2020 2005. Learned counsel for the petitioner submits that the said order was also impugned in the CRPIO number 375/2025. However, this court only dealt with the impugned order dated, which order?
same date, my 29/8/2025 in miss case Miss J case number 269 of 25.
Impugn order dated 29/8/2025 in Ms. J case number 279/2025. Learned senior counsel for the respondent also admits the fact that the impugn order dated 29/8/2025 passed in Ms. J case number 270/2025 has not been dealt with in the order under review. And he submits that the matter can be finally disposed of after hearing both the parties. Learned counsel for the petitioner prays for another date, fixing another date for hearing of this matter. The prayer is allowed. Let this matter be listed on Thursday, 8th of January. 8th of January.